All right, everybody, we're going to go ahead and get started. We'll go over a few housekeeping for tonight's webinar. Good evening. Thank you for everybody who is joining us tonight. I'm Nikki Whitaker. I'm the membership coordinator for the Kentucky Cattlemen's Association. And I'm going to let our guest speakers introduce themselves here in just a minute, but I would like to go over some housekeeping for our webinar tonight. If you are listening in via your computer or phone, you're automatically muted. If you have access to the chat buttons or the Q&A buttons below, we would ask you to use those throughout the presentation to ask our presenters some questions. We also will be conducting some polls throughout the presentation. So these are just survey questions that we're going to ask the attendees throughout the presentation, and you can answer those on the screen. So those listening in via the conference call number, you won't have access to those, but if you'd like, after the presentation tonight, we are recording, and we will put those up so that you can kind of see what those poll results were and those questions were. All right, so tonight we have Candace Smith and Laura Mays with Steptoe and Johnson. You may have seen Candace's articles in the Cow Country News the past couple of months, and we thought it would be a fun spin. I know that we've been doing a lot of webinars lately, production, education webinars, but we thought it would be a good spin to do some legal webinars, maybe how to protect yourself and your farm and your animals. And so we invited Candace and some of her colleagues to do these webinars. This is the first one that we've done like this. We plan to do another one in November, so make sure that you watch out for that. And then hopefully next year, once the holidays settle down, we might continue. And if you have any requests or any issues that you might want to hear about, just let us know. But I'm going to turn it over to Candace and Laura and let them get started. Again, I would just remind you that if you have questions throughout, just use that chat button below.
Hi, I'm Candace Smith, and thank you, Nikki and Becky, for helping put this together. We're really excited to be here with you tonight. As Nikki said, I work as an attorney for Steptoe and Johnson, and just a little bit about myself and kind of how I got interested in this. I grew up in a small town in western Kentucky in Graves County, and I grew up next door to my grandparents, and my grandfather raised some cattle and had ponies. And I have really fond memories of helping him plant our family garden in the summer so that we would have fresh produce for dinner every night. And unfortunately, I did not get his green thumb, but I do still have a passion for a local farm and for farmers in Kentucky. And my husband and I make it a ritual to go to the farmer's market every Saturday and really to try to support locally grown and raised food. So I guess just kind of my passion and personal interest in that led into my work with the Kentucky Cattlemen's Association. I've been writing articles for the Cow Country News for about a year now, touching on various legal issues just so the readers will be aware of some things that they might not have thought of before, to try to be proactive and make sure that the contracts they enter are valid, make sure that they're protecting themselves from injuries or liabilities, and then what to do in a situation that an accident does occur or you get sued, because that can of course be a really scary situation. And I've been trying to provide some tips about how lawyers can help you in those situations, and that's what Laura and I are going to be here doing tonight, is kind of expanding on that, specifically with respect to injuries caused by animals. And so we'll talk about some different scenarios in which you could be held liable for injuries, and then also kind of some best practices to try to avoid that. And I'll let Laura now introduce herself too.
Good evening, everyone. My name is Laura Mays. Candace and I both work in the same office in Lexington. I am a litigation attorney here in Kentucky, and I practice all over the state of Kentucky. State and federal court, and the cases that I litigate have a lot of different fun issues that may touch on some things that would be helpful. I do premises cases, some product, contract, construction cases, and a lot of employment claims.
All right, we are going to get started with the presentation. All right. So first, we're going to have a quick poll question, and then we will jump into the presentation. All right, it looks relatively even as far as injuries on property and injuries from your animals escaping from your property. And we will touch on both of those two topics in quite a bit of detail. But if you've got additional questions, then like Nikki said, you can put them in the chat box and we'll try to answer them at the end of the presentation. So just kind of to give you an idea about what we're going to cover tonight, first is going to be some general rules about liability for injuries caused by animals both on and off your farm property. We're going to give you some example scenarios for different types of injuries that could occur, and then explanation for why rules for livestock are different than rules for dogs. So dogs on your property are going to be treated differently than your horses and cows. And then Laura will talk about some tips for how to avoid liability, as well as some best practices for what to do if your animal does cause an injury. And these topics we're going to be discussing tonight, they involve a lot of general rules, and like most things, there's exceptions to the rules, which we unfortunately won't have time to go into in detail today. But there's a lot of gray area, as you see, as I'll go into the liability rules and some example cases. So this isn't legal advice by any means. I think a lot of these situations are really fact dependent, but hopefully it will help you identify things that you can do to proactively avoid an injury in the first place, and then also explain why it's important to take those steps on the front end. So for liability issues, there's really three categories that we're going to discuss: injuries caused by animals on your farm, injuries caused by animals that have escaped from your property, and then farm dogs. And the first is injuries caused by animals on your farm. And when I say farm or farm owner or farmer, that's just kind of a generic term I'm using. It could be any kind of property owner that would have animals on their property. So if you board horses or something like that, these same rules would apply to you. So in general, a farm owner has different levels of responsibility depending on why the injured person was on the farm, the purpose why that person entered your property. And some of the main categories are people that have business dealings with the farmer, people who have permission to be on your property, trespassers, children, and people attending farm events. The first category is people with business dealings. In a lot of cases, you'll see this referred to as an invitee. And the general rule is that the property owner has the responsibility to discover unreasonably dangerous conditions and either eliminate those conditions or give a warning to the person that's on their property for a business purpose. We're going to focus more tonight on visitors. And these are people who come to your property with permission, but they might not necessarily have a business purpose to be there. And the general rule is that farmers do not have to make special preparations for their visitor, sometimes called a licensee in the case law. And ordinarily, a farmer does not have to warn about dangers that are known or obvious. And again, what's known or obvious to one person is going to be different than what's known or obvious to another person. So someone that comes to your property and says they've never seen a cow in person before, they've never been to a farm before, a danger might not be as known or obvious to them as it would be to someone who has experience with cattle. And a really good example of this is the case Baker versus McIntosh. In this case, a family friend came to the farm unannounced. And while he was there, the farmer was in the process of loading horses onto a trailer. The family friend offered to help and was participating in that. And during the process, one of the colts that was being loaded kind of got loose, got away from the farmer that was loading the colt, and ended up injuring the friend that was helping. The court ruled that the potential danger of rambunctious and skittish colts was obvious. And as a result, the farmer was not liable for that injury. The farmer didn't have a duty to warn because the potential for risk was obvious. And then a few years later, another Kentucky court applied that same rule in a case Lovelace versus Ringstaff. Now, in this case, Lovelace owned his own cattle farm. So he was a very experienced cattle farmer and experienced in the industry. He was at his friend Ringstaff's farm, and again, he was helping him load cattle in this instance. He'd done this before. He was doing it without compensation, just a friendly gesture. And during the process, one of the trailers that they were waiting on to load the cattle was late. And as a result, the cattle started getting kind of hot and restless. And then when the trailer finally did arrive, Lovelace ended up getting injured by the cow. And the court, Lovelace ended up suing Ringstaff for his injuries. And the court ruled that the Baker rule, that farmers don't have to make special preparations for the visitor, and that ordinarily they don't have to warn about things that are known or obvious. That same rule applied with even more force to this case because Lovelace was experienced in the cattle industry. So any potential risk that existed would have been known to Lovelace. And as a result, Ringstaff was not liable for the injury caused by his cow. Now, both of these two examples show situations where the farmer was not liable because the injury was known or obvious. But you can, of course, imagine scenarios when the opposite might be true. When someone might be at your property and they don't understand that a horse or cow is loose, or they go to open a barn and you haven't properly secured an animal and the animal runs after them. So there are situations where liability could be found under this same rule. It's just that these two particular cases came out in favor of the animal owner. And another general rule is that the owner of a domestic animal, like a horse or a cow, that's not known to be abnormally dangerous, is usually not liable for the harm caused by the animal unless the owner did something to intentionally make the animal cause an injury or was negligent in failing to prevent that harm. So generally, you're not going to be responsible for an unexpected abnormal behavior from your domestic animal. And the next category of potential people that could be on your property are trespassers. Now, trespassers do not have the right to enter your property. They're there without permission. And this rule generally says that farm owners are not liable for injuries to trespassers caused by the animals unless the farm owner acted intentionally. There is an exception, though, for children. And the law gives extra protection for children just because it recognizes that children might not appreciate and understand the inherent risks of certain types of machines, features of property, in some cases animals. And so the law steps in to kind of protect them and also put an extra burden on the adults to try to protect the children. And the way they do this is through the attractive nuisance doctrine. And I wrote an article about this a few months ago in the Cow Country News magazine. But in general, it's going to depend on several factors that courts have to look at. I think that it would be rare for a court to find that an animal would be an attractive nuisance, especially an animal like a cow or a horse or a chicken that is generally a domestic farm animal without any known dangerous propensities. But the factors that you would consider are whether you have a reason to know that children would be likely on your property where that dangerous condition exists. And so if you've seen children on your property and, without permission, they've just hopped over a fence and they're playing on your farm and everything, then you'd have a reason to know that children are going to be on your property. The next would be a reason to know about the condition and the unreasonable risk of injury it presents to children. So if you happen to know that one of your animals has a tendency to be dangerous, then you might be aware of that condition. The third factor is children don't understand the risk of the harm. And a lot of times children aren't going to appreciate the risks that an adult would appreciate. The fourth factor is the risk of injury outweighs the difficulty in eliminating it. So if you could take a pretty simple and inexpensive step to try to prevent the injury and you fail to do so, that factor is not going to weigh in your favor. And the final one is the owner does not take reasonable steps to eliminate or protect the children. Reasonable steps is really fact dependent, and it's basically looking at what a reasonable person in your shoes would do. An example of this doctrine in practice is North Hardin developers versus Corcoran by Corcoran. And in this case, a 5-year-old little girl entered the property of the farmer without permission and on a dare went up and touched a horse and unfortunately was kicked by the horse and injured. And then her family sued the farm owner. The court ruled that the attractive nuisance did not apply in this case. Again, the court said that generally domestic animals like horses and cows do not create an unreasonable risk of harm to children and are not an artificial condition. So the doctrine just did not apply to this particular animal and this condition. However, the court left open the possibility that a different result might have happened and the farm owner might have been liable if the animal had not been secure or had a history of dangerous behavior. So each of these cases is really going to be fact dependent. The important thing to remember though is that if you've got children that you see on your property that are not your kids or your employees' kids, they're just entering the property to play, it would be better to try to prevent them from doing that, because if they're being unsupervised, then there's a higher likelihood that they're going to get injured somewhere. Another category is participants in farm activities. And again, Kentucky law has kind of stepped in and made some special rules because something was of interest. And so it required them to try to change the regular law a little bit for these particular activities. So Kentucky law encourages farm activities. And one way they do that is to limit the liability that a farmer might have for those activities. The law recognizes that there are inherent risks of farm animal activities, which are beyond the reasonable control of a farm animal professional. So the general rule is that a farm animal professional is only required to reasonably warn participants of those inherent risks. They don't have a duty to reduce or eliminate the risks. Now, you have to fit into a lot of different categories in order to be protected by this rule. But the first category is you need to be a farm animal professional. And so this is someone that's being paid for the farm activity they're doing, such as instructing, training, boarding animals, providing veterinarian services. There's several different things that qualify for this, and they're all included in a statute under Kentucky law. The next is you have to be participating in a qualifying activity, such as a show, a fair, a competition, teaching, a training, again, veterinarian services, things like that. And then the animals that are involved need to be farm animals, which include a variety of animals. A few of them are cattle, sheep, horses, poultry, pigs, things like that. So if you have qualified, you've met the farm animal professional requirement, it is a farm activity and it involves a farm animal, then in order to be protected, participants must still act in a safe and responsible manner to avoid injury. The person that's hosting the event must reasonably warn participants of the inherent risks associated with that activity, but they do not have a duty to reduce or eliminate the risks. Now, there is an exception for participants that have experience with those risks. So if you happen to know or someone tells you that they're very experienced in this activity, then they might qualify for this exception where you wouldn't have to warn them. However, I would say the best practice is to definitely go ahead and warn them regardless. You'd rather be safe than sorry. And again, the whole point is to try to avoid an injury. So the more information that people know, the better. The way that you can warn of these inherent risks is that you must post a sign, and the statute is very particular about what you have to do as far as giving kind of warnings and notice. So the warnings must be posted in a sign in a clearly visible location near the place where the activity itself is going to take place. And then the statute provides specific language about what that warning should say. You should say, warning, under Kentucky law, a farm animal activity sponsor, farm animal professional, or other person does not have the duty to eliminate all risks of injury of participation in farm animal activities. There are inherent risks of injury that you voluntarily accept if you participate in farm animal activities. And if you have any kind of written contract or agreement related to this farm animal activity, you have to include this same warning in writing in that contract. So those are some, just kind of an overview of some general categories of people that could be injured on your farm property, engaged in different kinds of activities, and there for a variety of purposes. But something that I believe is a concern of a lot of the membership of Kentucky Cattlemen's Association is injuries caused by animals escaping from your property. And I'm sure that that can be a really scary thought, because you might have done everything you needed to do that day, put your horses or cows away and all your animals, locked all your gates, you go to sleep, and then you get a call in the middle of the night that one of your animals has gotten loose. And I'm sure that would be just, your stomach would drop. You would be very nervous and trying to get the animals found and under control as soon as possible. And unfortunately, there are some rules that make animal owners liable when the animal gets loose. And a lot of it's going to depend on the steps that you took to try to keep the animal secured in the first place. So there's a statute under Kentucky law that prohibits a cattle owner from letting your cows just run at large. You absolutely cannot do that. But in order to determine whether you're liable, courts are going to look at the steps that you took to try to secure your animal. If you did let your cows just run at large, then you are going to be liable for damages caused by your cows. So whether you're liable depends on whether the person in charge of the cattle was negligent in permitting the cattle to escape. And as a general rule, the unexplained presence of a cow on a highway creates a presumption that the owner of that animal was negligent, that they did something wrong, which the owner can then rebut with evidence showing the owner used reasonable care. So basically what this rule means is that if your cow gets out in the middle of the night and is on the highway and causes a wreck between some vehicles, things like that, because the cow is on the highway, then the law is going to assume that you did something wrong, or else the cow wouldn't have been there in the first place. However, you can counter that presumption by affirmatively showing the steps that you took to try to protect that from happening, to try to keep your animals secure and safe, and to try to protect the public. So you need to be able to come up with evidence showing that you did take reasonable steps and you acted like a reasonably responsible person in your same position would have done. An example of this, and the actual case name of this is Oliver Trucking Company versus Harris. In this case, again, a tractor trailer hit a cow on the highway, and afterwards the tractor trailer company sued the cow owner. And this was one of those situations where the cow owner was asleep in the middle of the night, gets a call that his cows are loose, and called his friends to try to track down the animals. And unfortunately, they did not get them until it was too late and this accident had occurred. Then when they eventually had a lawsuit and everything, the truck company presented evidence showing that the fence that was enclosing the cow was rotten, and that a reasonable inspection would have revealed that. The cattle owner, however, had his own evidence that showed that the fence was in good condition. And the court found that that evidence that the fence was in a good condition was enough to rebut that presumption of wrongdoing. It didn't necessarily mean that the cattle owner was not liable, but it rebutted that presumption. And by doing so, the case actually got to go to the jury, and then it got to be in the jury's hands to decide who was at fault. Now, sometimes you're transporting animals, maybe to a slaughterhouse or to a buyer. There could be a wide variety of reasons why an animal would be transported. And there's not as many cases on this issue about who is liable if your animal escapes during the transportation process. Maybe somebody failed to properly enclose the trailer, or the trailer transporting the animal gets in a car wreck, an accident, and then the animal gets loose. But the same general rule about controlling your cattle, I think, would apply in this situation. So that same statute that prohibits a cattle owner from letting their cows just run at large also prohibits someone from letting a cow in their custody run at large. So that person that's transporting the cow would be in violation of the statute if he or she does not use reasonable care to try to prevent the animal from escaping. And those are the general rules about some domestic animals and what kind of liability you might be facing if they either cause an injury on your farm or if they cause an injury off your farm and in the transportation process. And then I think we had a polling question about dogs that I'll let Nikki put up before I get into the next slide.
And Candace, we did have a question from one of our attendees. I know we're going to have a Q&A session, and maybe Laura will cover it as well. But it talks about homeowners insurance. Would you like to take that now or maybe a little bit later?
Why don't we can go ahead and get the question out here, and then I'll try to answer the best I can, but it might be something that Laura will be prepared to answer as well during her presentation.
All right, well, while everybody's answering that polling question, the question was earlier when you were talking about injuries, wouldn't homeowners insurance cover any injuries?
I do think that homeowners insurance would cover a variety of injuries. It's going to depend on the particular language of the insurance and how much coverage you get. So if you have very minimal insurance and a child dies on your property, then I think you might be on the hook for some of the additional damages. There might also be some exceptions that would apply to that policy that might prevent you from being protected. So Laura, I think we'll be discussing that in more detail. It's going to be really fact dependent, but I think that's a really good point, that it's good to have insurance for your business, for your property, so that if an injury occurs, hopefully you wouldn't be out of pocket. I would say that even if you don't have to pay anything, it can still be very time consuming and a large burden to have to deal with a lawsuit, because you're going to have to produce a lot of your documents. You're going to have to maybe testify. Your employees might have to testify. So obviously you'd rather not have to pay out of pocket, and having insurance can be really helpful for that. But it's still something that you would want to try to avoid the injury in the first place, so that you don't have the additional headache and stress of the lawsuit itself.
Right. All right. Thank you for that. And here are our results from, do you own a dog that you let outside on your property?
Okay, well, that less people than I expected said yes. So I'm going to talk about dogs for a little bit, just because they are treated differently than cows, horses, chickens, the other farm animals we've discussed so far. And the reason they're treated differently is because Kentucky law thinks that dogs are considered less disciplined and more likely to be vicious than your typical farm animals. I think that a lot of dog owners might think otherwise, but just in general, there are some dogs with some vicious tendencies. And so this law is in place to try to protect people from injuries from such dogs. So as a general rule, dog owners are automatically liable for injuries caused by their dogs. So unlike the presumption that we talked about if your cow gets loose, where you can rebut that presumption with evidence showing you acted reasonably and responsibly, with this rule, you're automatically liable. And so it's really important to make sure that your dogs are enclosed, and that if there's people on your property, they're not I guess, interfering with your dogs, riling your dogs up, causing something that might make your dog want to feel like it needed to attack or protect you. The statutes that touch on this generally say that if a dog owner has been ordered to confine its dog because the dog is vicious, you cannot let your dog run at large, and you cannot let your dog be out in public. There's a few exceptions for getting veterinarian services or taking your dog to a shelter. But in general, if you're ordered to confine your dog, you must do that. A vicious dog that's running at large can be killed without liability by an animal control officer or a police officer. And the owner of a dog is responsible for the injuries the dog causes, even if the owner acted reasonably to try to keep the dog from escaping. And you might have heard of something called a one-bite rule. Kentucky does not follow this rule. So that means that the owner is liable even if your dog never showed aggressive tendencies before causing this injury. And that is kind of a summary of the potential injuries that you might be experiencing on your farm and potential liability that you might be experiencing. And I'm now going to pass the presentation over to Laura, and she's going to give you some tips and best practices.
Okay, thank you, Candace. I think do I have control? I think I do. Thank you. Okay, Candace did all the heavy lifting. I get to do some of the more big picture, maybe some real life scenarios or things you may see. The law is very protective of injuries that happen because of animals. So I'd like to back up just a little bit, do a little bit bigger picture of some other injuries that could happen or some other dangers on your property that you may not think of or may not be aware of or spend a lot of time trying to fix. But I'm going to talk about simple ways to prevent injuries, things that you can do to prevent injuries. And then we'd like to close it up with talking about some, after an accident happens, what you can do to reduce your liability on the other side of that. So the before and after. I want to jump off a little bit what Candace said. Legally, I'd like to focus on the two types of visitors, the business invitees, and then we call them licensees, the visitors that are invited onto your property. So if any visitors are coming on for business, or they're coming on because they're there to visit you, there can be some liability in a lot of different areas. The two things that the law focuses on here, and these are premises liability cases that I've had that I'm talking about now, but the two terms that come up pretty often are one that Candace mentioned, an unreasonably dangerous condition. So I'd like to jump in a little bit and give you some examples of what may be an unreasonably dangerous condition on your property. And I'm a little bit, it's difficult to do that in general terms. I'm going to do my best because I don't know your properties and I don't know the specifics, which are always in play. But we want to talk about unreasonably dangerous conditions. And then the other term that gets a lot of play in these cases that it may be helpful for you to know about is the term foreseeability. So when courts and juries are evaluating property owners, they are looking at whether the injury was reasonably foreseeable by the owner. So those are the two we're going to keep coming back to. As Candace mentioned, let's talk a little bit about the animals. So with animals escaping from your property, there are obvious things you can do, and I'll talk a little bit more about this in just a minute. But obviously, secure the animals, right? Check your fencing, check your gate latches, check your transportation vehicle latches, and I would recommend doing that periodically and documenting it because the key, as Candace was talking about, is evidence. So we're trying to create evidence when you do those things. And then if you do have animals that show aggressive or violent tendencies, you may need to take some extra steps to try to secure those animals to prevent them from harming your visitors. Okay. Candace, I'm not able to get it to go to the next slide. Are you? Nope. Okay, thank you. So I want to break this down a little bit into hazards that you can control and maybe some hazards that you can correct. And then I want to step in to talk about some of the things you cannot correct. So this is big picture property owners, what we're talking about. So, bad latches, get in and fix those. Things that you may not think about if you have utility vehicles, or vehicles that have several latches on the back. I actually had a case that's crazy, and we actually had to spend money to defend this case. But my client was driving a utility vehicle, and a bad latch on the utility vehicle had a door open and hit another car and caused damage to that car, and we actually had a case about it. So check things that you maybe not normally think to check. Exterior ground level hazards and interior ground level hazards. Again, I don't know what your properties look like, but I would recommend, you don't have to go out on your property, obviously, and search for holes or maybe like hidden holes that have some, longer grassy areas. But if you know about those things, if you know about some of those hazards, and if it's easy to fix, that's what I would recommend, fixing those. Walkways, I would pay particular attention to the walkways on your property where you know that your visitors are going to be traveling. So here's some examples of cases in Kentucky. The Kentucky Building Code actually provides some guidance on how high steps should be. I've had cases where if a step is very high or even very low, which is it's just not standard, cases where somebody will come in and say it was unexpected and it was unreasonable. So pay attention to your steps. If you have large cracks on any of your walkways, and if it's something that's easy to fix, I recommend fixing those. If you have employees, a good source of training, good thing to do with employees may be to train them on debris. And I know that this may be difficult in the farm setting, but again, I deal with cases almost every day where plaintiffs have filed lawsuits because of debris. And I'll get into that a little bit more when we talk about what to do after the accident. Cables and hoses are another area where I have a lot of cases. Put the cables away, put the hoses away when you have visitors on your property. But one thing to think about is, we talk about dangers being obvious, open and obvious. I have found, and I've been able to defend cases where, for example, I've got a bright yellow hose on a black asphalt. So anything you can do to draw attention to something that could be considered a hazard will be helpful. It may prevent the injury, and then if it does cause an injury and we end up defending it, you end up defending it later, it makes it a little bit more defensible. Okay. I don't know if you have lofts or high areas. Take some steps if you can to secure items or product in high areas from falling. And then wet areas. Wet areas are a huge part of premises cases in Kentucky. Sometimes it's not always, you can't always fix an area that wet, or if it's wet or gathers water. So think about commercial grade mats on your property. Again, it may prevent the injury, but if it doesn't prevent the injury, we often use that defense that there were commercial grade mats purchased, they were put down, and it shows that you're a reasonable landowner who's trying to prevent injuries. Okay. All right. To the extent, if you can, identify those unreasonably dangerous conditions and correct them, I think that's great. And please do it. That would save you. But there are some hazards that you may not be able to correct. So what you can do there to reduce your liability is to make it open and obvious, like we talked about the hoe. Make it something where you warn the visitors on your property. So signs, cones, any kind of signs for animals, wet, slick areas. We talk about ground hazards. If you have a large crack in a walkway that may be an unreasonably dangerous hazard, orange spray paint on the crack, anything to draw attention and make something more open and obvious. Okay, Candace talked about some, nuisance, attractive nuisance for children. And when I'm thinking about my own family that has farms, I'm thinking about the pond on their property. I'm thinking about the four-wheelers and the side-by-side, the rhino, gators. So my suggestions there would be to lock or secure any areas that you can. And I know that that's not always possible. Signs are helpful, especially if you know, like Candace was talking about, if you know that children are coming onto your property. You can speak to children, tell them to leave your property, and we would recommend that you do that. But you may also, again, we're just trying to create evidence to reduce liability. You may try to document. So if children are coming on your property and you're telling them to leave, it may not be a bad idea to document that for yourself. And then with any four-wheelers, side-by-sides, I know my family likes to keep the keys in the four-wheeler. It may be a good idea to secure those. Anything you can do to prevent children coming on and getting hurt. Okay. This slide focuses on trying to create the evidence that you would need to show that you're being a reasonable landowner. I would recommend scheduled inspections. And I know you are on your property, you're walking around your property, you're looking at it, but I do not see very often times when folks have an inspection schedule in place, maybe written down, and then documenting the inspection. So something that could be very helpful if there is, if an animal gets loose and harms someone and the burden shifts back to you to say, okay, what did you do to prevent that from happening? It would be great in a defense to be able to say, here's my inspection schedule. I did it in August, I did it in September, I did it in October. Here's what I found, here's what I corrected. I didn't find any issues. Just the paper trail by itself is very helpful. Any repairs that you do, I do recommend that you document repairs. If there are things that are wrong, definitely do that. For transporting, I know there wasn't as much, looked like the percentage was a little lower with folks worrying about transporting animals. But any kind of traffic accident that you're in or that your employees are in, it's always helpful to have the documentation to show that the equipment has been maintained, the trucks and the trailers, everything has been maintained, and it's a safe vehicle on the road. And then I'll talk about this a little bit, and it'll come up in just a second as well. If you have frequent visitors on your property that are doing business on your property, it may be a good idea, something to think about for your farm going forward, is a written contract with those frequent visitors that are doing business with you. What the written contract can do, obviously, it outlines the obligations of the parties, the rights of the parties, but you can also add a clause in there. So there was a good insurance question, right? So you can have your own primary, either homeowner's insurance or general liability insurance that would cover you to a certain extent. So, but you'll have your deductible, you'll have your limits. You can also, if you have a written contract with a business invitee that's coming on and doing business with you, you can have a clause in the contract that would make you an additional insured on their policy. So if they're coming on, let's say you lease a piece of property so that they can have use it for their own animals, or they're coming on to provide a service to you, have them add you onto their insurance as an additional insured. Something to think about. And that would just give you that extra coverage. If you have employees, again, anything you can document. So come up with the training that you would like to provide your employees. And when I think about training for employees, I'm thinking defensive driving, safety training with operating equipment, and safety training with handling animals. Sometimes I've noticed some maybe worth checking with your insurance company. Sometimes insurance companies will provide that training. So I do some work for some insurance companies, and they provide training to their insureds to show their employees, for example, forklift training or heavy equipment training. And being able to say, this is the training I gave my employees, and having the employees sign off saying that they got that training is really helpful. and being able to say, you know, I teach my employees that we're all responsible for the conditions and doing whatever they can to help. Empowering your employees, that helps you too later when you're defending. Okay, this is what I was talking about. Definitely you want to try to avoid your out-of-pocket costs. So your personal insurance coverage would cover, I mean, it depends on your policy and it depends on how much coverage you have in your policy. And I completely agree with Candace. There may be exceptions. So you may want to look at your policy and see what it actually covers. But in addition, a personal insurance coverage may also provide a defense. And that's what I would go and double check and make sure that you get that as well. Because defense costs and litigation can be very expensive. And a lot of time that insurance coverage, if you don't already have it, will be helpful in that situation and provide defense and pay the cost of an attorney for you. And then the additional assured coverage, that would only be by contract with someone who's coming on your property. Okay, those are, and the law does, I want to make real clear, the law does not necessarily require you, and it does not require you to go out and search for hazardous conditions on your property. It does not require that of you. But in an effort to prevent injuries and prevent cases, that's just some things that I'm recommending that I've seen in cases that would be easy fixes. Okay, so after you've had an accident, if something happens, if an animal hurts someone on your property, if there's more of a premises, somebody gets hurt on a walkway or gets hurt, a child comes on and gets hurt, here's what we would recommend doing immediately after the accident. Before, you want to collect information. It's very important to collect information. And I know sometimes it may be difficult to kind of keep your head about you and remember everything that you would need to collect or that would be helpful to collect to reduce your risk and to be able to defend yourself later. One important thing to do is to alert your insurance. Your policy will say how you're supposed to alert your insurance, and it'll tell you the steps to take and who to contact. So it may be a good idea to have that handy in case there is a traumatic accident, that you would have that handy. Which, second, if you have an attorney, even if it's at night, it may be a good idea to call the attorney to come. You know, we have an emergency response team. I've left Lexington at all kinds of weird hours to travel to an accident. And there are a couple things that's helpful for. You know, we do this for a living. We know what evidence is important and we collect it, but also some of the investigation will be protected if an attorney is involved that may not otherwise be protected from discovery later on or from the other side finding out what we find out. It is important to collect relevant information. So, you know, when I go on to a scene, or if even you, when you're responding, it may not be a bad idea to develop your own incident report. And what I would envision on that report is just the who, what, when, where, why, with blanks to remind you of what you need to collect. Just have those with you in an electronic form or paper form and be able to kind of fill that out and document what happens. Pictures are always important. I think people maybe forget about pictures sometime, but pictures of the actual injury can be helpful, of the person, of the property that's damaged, whatever the dangerous condition. You know, if they're saying that this was dangerous, this hurt me, whatever that is, pictures are helpful. And then weather conditions can be helpful. You know, if there's wet areas, if it is raining, then someone should be on guard and protect themselves from falls because of excuse me, because of water. So take pictures of all of that. Witness statements are important, and I'm not talking about anything fancy here. I'm talking about locating the people who have any relevant information about what happened, who were present, someone who spoke to a witness shortly afterwards, and it really is, here's my name, here's the date, here's what I saw, with a signature. And those are surprisingly helpful in litigation when that happens, because, and it's more helpful when it's close in time, to the event immediately after is great. Video. I don't know if you may have any kind of mounted surveillance system on your property or video from your phone. Either is helpful, but video can be helpful. It's important to document who is on the property when the accident occurs and have their contact information. So litigation can happen years after the accident occurs, and it's difficult in a lot of cases that I go in and we try to locate this information, and it can be difficult 1, 2, 3 years later. So being able to document who's on your property, what employees saw this, and being able to provide their contact information really helps us in tracking down the information that we need later on when litigation is happening. And then this is, when I was talking about the documentation with inspecting, this is where it really becomes helpful. So, if there's some dangerous condition on your property that hurt this person, it is really great to be able to go back and say, when was the last time we looked at this property before this happened, right? And if it was in recent time, if it was within a few weeks or within a month that we looked at this and it was okay, that's helpful. So I recommend documenting that, and also immediately after. So it's right after an accident happens, we really need to know what the condition was and what state it was in as soon after the incident as possible. So being able to go and inspect the area and the condition and whatever it is, and providing as much detail as possible about that condition is very helpful. Okay. So this slide focuses on, when I'm recommending to you that you do an incident report or a witness statement, it's helpful if you're the one doing that, it's helpful to know, what am I really looking for here? So if someone is hurt on your property, and this may end up in litigation, here's what we really want to know. Who is at fault and why? We want to know the extent of all the injuries or damages. For example, if it is a minor injury to a vehicle and the person inside is claiming really traumatic injuries later on, it's helpful to be able to go back and look at what was the actual damage to the property. Another question that is important is, can you get any information about whether this person was injured before they came onto your property? And I have had cases where someone falls on the property and they tell the property owners, I was really dizzy. I fell because I was really dizzy, and they will say the reason. Or, I fell because of my shoe. They'll being able to find out anything from before. Or somebody would say, I had a case where someone said they had surgery the week before, and this was the first time they had been out of their house since they had surgery. All right. Ask the person what caused the injuries and damages. You may say, what happened to you? And this is where they say, I tripped over my flip-flop. They say that to you at the time, and then in litigation, they may come up with a new reason that's basically saying, there was something on your property that hurt me. So being able to document all that is great. And then the big picture-wise, right, is it an open and obvious condition? And if it is, please take pictures of it. So I've had cases where it was a wet condition, and we've got pictures of the person who had fallen, and the property owner tells me I had cones up, I had big orange signs, but there's no pictures of the orange signs, right? So when you're taking these pictures and you're collecting everything, if you did anything, if there's a sign up, if there's cones, those are important. It's important to show that those were there at the same time. Okay. And collecting all this information shortly after the incident is important, because the statute of limitations in Kentucky for personal injuries is 1 year. So they can wait a full year before they first file the complaint. And then it takes us a month or two to kind of get in and figure out what happened and to be able to file an answer. So you could be looking well over a year after the accident that we're really needed to come in and figure out what happened. For motor vehicle accidents, it can be 2 years or even more. It's can be based on when certain insurance payments are made, but at the minimum it would be 2 years. So and motor vehicle under Kentucky. So I've had cases where we've had to apply this really long statute of limitations. Involves, it can involve like a forklift. Somebody's moving a forklift or some other heavy machinery, then that longer statute of limitations can apply. If you have an accident, after you've done all these things, just be on the lookout. So if you are served, if someone decides to file a lawsuit, you have to be served with a complaint and with a summons. And if you receive that complaint or summons, you are required under our civil rules to file a response within 20 days in Kentucky State Court, 21 in federal court. So it is important as soon as you receive that documentation to both alert your insurance so that they can assign counsel for you or reach out to your personal attorney so that they can protect you in the litigation process. If you don't file the response within those days, then it is possible that you would just get a default judgment against you, and then a plaintiff could just move forward with collecting their judgment. All right, and then we said notify the insurance company. So that's all for me.
Thank you, Laura, and thank you, Candace.
Thank you.
I'm going to wait and see if we have any questions pop up on our chat box here. In the meantime, I think while I was listening, I know I had a question. Many times our county associations will gather at a farm, to do a tour. And I think you all have given a lot of good tips about hazards and looking out. Is there anything, during those tours or those county visits to a farm, is there anything that the farmer that they're visiting can do ahead of time to maybe make everything good and protected and make himself protected before that group visits?
I think there's a possibility that visit would fall under the farm animal activities that I discussed, in which case you should post those warnings in the areas where the participants are going to be. And like Laura mentioned, getting things in writing, it would not be a bad idea at all to hand out something where people are signing an agreement that they understand there's inherent risks, things like that. If you know that there's going to be people traveling through an area where animals might be loose or where they might come in contact with the animals, then I think you should definitely give them a warning.
All right, I'm looking to see if we got any other questions. I know I had another one as I was sitting here listening. So I know we were talking about animals tonight, but do the same at fault or liability rules fall under, faulty equipment? Say you're sitting on the back of a tailgate and the tailgate breaks or something, or you're taking a hayride and the wagon comes apart from the truck. Is the same liability rules in play there?
I think a lot of the same rules apply. I know that some of the things I touched on relate specifically to animals, but things like the attractive nuisance doctrine that we talked about, and people that are the invitees that are on your property for business purposes, or the licensees who are just on your property for any kind of reason, but they have permission to be on your property. I think the general rules about what you have to do with warnings and everything applies regardless of whether it's an animal causing the injury or some sort of equipment, or like Laura touched on, a lot of things just on your land itself might be a hazard that you would need to warn someone about or try to take steps if you can to try to protect people from getting injured.
Mm-hmm. Well, I am not seeing any questions coming through. So, but for our attendees tonight and anyone who happens to listen in to this recorded session on our website, where can they find you guys, or how can they get in touch in case they have any questions?
Yeah, like Laura mentioned, we both work in the Lexington office of Steptoe and Johnson, and we have about 14 different offices across several different states, but we have a Lexington and Louisville office in Kentucky, and Laura and I both practice all across the state. And so, even though we are based in Lexington, we are happy to drive out, a couple hours. It's not a problem at all. And that's a lot of what our practice includes. So you can find us at, I guess we can post the contact information on the presentation when we give it out, but you can certainly contact us by email or by telephone. Our information is on our firm's website, and we would be happy to talk with you if you've got any of these concerns about how you can, try to put some of these proactive things into place. If you wanted to create a checklist for, if an injury occurred, or if you wanted to have someone look at your insurance contract to make sure that you're covered. That's this kind of stuff that we do every day. So we'd be happy to help you.
Awesome. And we did get the question, can we get a copy of the presentation? And yes, we will be emailing this presentation to those that registered for the presentation tonight. So yes, you will be getting that, and the contact information will be on there as well. Well, I know, oh, go ahead, Laura.
Oh, sorry, no, I was going to say, I'm not sure if the actual, I'm not sure if the slide listed every example that we had, so I will send you a list of that so that it can be added, or that you can send it on.
Perfect. Yeah.
Okay.
Well, like I said, I know that for, again, our producers, we have a ton of people who host tours, and I thought this was great information. This is a different type of webinar that we thought would be helpful. So I thank Candace and Laura so much for coming tonight and presenting. Tonight's presentation was hosted by our Kentucky Beef Network. And like I said, I'm with the Kentucky Cattlemen's Association. So again, if you happen to catch this on the recorded side, just feel free to email our office at info@KY-Cattle if you have any questions. Otherwise, look out for the November webinar that we will also do with Steptoe and Johnson. And if you have any ideas for other topics we can cover, just let us know. All right, thank you all so much again. Have a great evening.
Thank you.